So the motion's denied.
Karen Read's retrial is about to start, and on the eve of that second trial, Hank Brennan kind of got his head handed to him on one of his motions, and there's also a brand new attorney. There's more.
Can the perceived bias in court finally be over? I'm Lainey Law.
I don't know about that, but I'm attorney Andrew Myers.
So it sounds like we have some updates that are good updates, potentially, depending on which, if you're siding with the prosecution or defense. But a lot of people have been feeling like the prosecution has just kind of been getting their way with everything. So it sounds like we're finally slowing that down a little bit, at least.
Well, yeah, the absolute final pretrial hearing was held 1 week before the trial gets started, and we're on the eve of that now. And two issues were debated in that hearing. One of them still hasn't been decided as we record this, but that could change at any moment. The first issue was this third-party culprit defense, in which the defense says Karen Read was not responsible, and they've actually now named three people that they say could have been the third-party culprit. Of course, Special Prosecutor Hank Brennan is not happy about that. And the second issue in the final pretrial hearing, of note anyhow, there were other issues, but the second major issue was this motion that the special prosecutor raised to go into Karen Read's telephone and find out information about texts between her and her attorney, violating attorney-client privilege. So the judge acted on one of those. One of the major issues in this final pretrial, of course, was the prosecution's motion to block the defense from suggesting that someone other than Karen Read was responsible for killing John O'Keefe. It is the so-called third-party culprit defense. Special Prosecutor Hank Brennan said the first named culprit, Colin Albert, had no motive, despite claims that as a neighbor, Colin Albert once angered O'Keefe by throwing beer cans on O'Keefe's property. And as
it's
for
less of a motive than like they're like, oh, that's no motive. He's like littering on his property, throwing things over in anger, versus like, oh my God, my boyfriend's talking to a different girl on a cruise.
Well, the remorse, it goes deeper than that, but that was one of the things that kind of came out. Maybe there was a motive, maybe there was a long-standing feud, but Hank Brennan said, nuh-uh. And as for the second culprit,
Brian Albert, and this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it, and even if it was so, has nothing to do with this case. Known as a bully, so rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing.
Okay, so Brennan went on and he argued that a flirtatious relationship that we've all heard about between Brian Higgins and Karen Read was just that, and that Read's ultimate ghosting of Higgins never rose to the level of giving him a motive.
What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe.
Now, a separate but related defense that the special prosecutor seeks to keep out of the trial is the so-called Bowden defense. And what the Bowden defense means is that defense attorneys would point to serious flaws that we have all heard about in the law enforcement investigation.
Because at the time the police were doing this investigation, what they knew is that John O'Keefe was on the front lawn of 34 Fairview near the street. They knew that he was dying or is dead, and a number of witnesses knew that Ms. Reed was saying, I hit him, I hit him, I hit him. A number of witnesses. Shortly thereafter, what the police knew is that Ms. Reed's taillight was cracked.
So Hank Brennan and the special prosecutor is trying to keep out any evidence that the police made a mistake. He's trying to keep out any evidence of a third-party culprit. But Karen Read's defense attorney, David Yanetti, said that there is ample evidence to support the third-party culprit defense and pointed out that the Commonwealth actually misinterpreted the law. Yanetti explained that there are 3 separate legal concepts, and he explained them in court to the judge.
Your Honor, the Commonwealth's motion raises 3 interconnected issues, not just 2. I believe that 2 of those were conflated by the Commonwealth. I'd like to separate them out. The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe. The second issue, which I think was conflated with the first, is whether after the introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death.
And Yanetti went on to support the third-party culprit defense. He pointed to serious issues, including the credibility regarding Brian Albert and all of his house gets the night of January 29th of 2022.
At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard where Mr. Brennan claims that he was at the relevant time period.
And in support of the third-party culprit defense, Yanetti also pointed out a number of other facts, only 2 of which I'm going to address right this second. One of them is phone records of calls between Higgins and Brian Albert, which both men denied and explained away as, they were butt dials. And the other one is that both Albert and Higgins got rid of their phones. And if you'll remember correctly, Higgins cut up his SIM card and went all the way down to a military base on Cape Cod. So those are 2 of many reasons that Attorney Yanetti argued that the third-party defense is the third-party culprit defense is something that should be allowed in. Now, you'll remember in the first trial, it wasn't allowed in entirely, but there was kind of a hybrid ruling by the judge, and I think most of us expect that that is what will happen this time, that some of the evidence will be allowed in, maybe not all of it, but it seems like if it's not allowed at all, that would be one more grounds for appeal. And of course, we all hope that that's not necessary.
And I do want to add, sorry to interrupt you real quick, but just even thinking about like the phones and all of that stuff makes me think it's just like, if Officer John O'Keefe was supposed to be coming to this house to hang out, why did nobody care that he wasn't there? Was anybody calling him trying to figure out where they were? He just disappeared. Oh, he's gone for the night. I guess he went home. Like that's also an interesting point.
That's a really good point that people have raised, and there's never been any explanation for that. There's never been any explanation. They knew he was coming over. They had invited him in one of the bars. Brian Higgins, said, we want to see you. Come on over. Come on over. We want to, have a few more. It's closing time at the bar, but we can have some more fun. Come on. And that question has never been answered. And so it's one of those cliffhangers for the jury. So the next big issue that was raised in this final pretrial before the trial gets on, I can't believe we're actually talking about going into the trial, but
again,
here we are. Yeah. The next big issue was the Commonwealth's motion to get into Karen Read's phone to examine messages between Karen Read and attorney David Yanetti. Brennan arguing that Read waived attorney-client privilege by talking to the media about her conversations with Mr. Yanetti.
And we believe we have an entitlement to the information in the narrow area where Ms. Read has waived her attorney-client privilege. Specifically, where the defendant intentionally divulged the content of her communications with attorney Yanetti about liability and potentially striking John O'Keefe with her car. Those subject areas in that narrow time frame are no longer privileged because they're now public. The Commonwealth has identified a very narrow window, and that's a 3-day period. And that is what is mentioned by Ms. Read in her public statements, that she spoke to Mr. Yanetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area in which where Ms. Read waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related.
But at the same time, defense attorney Robert Alessi got up to the podium and he broke down the actual facts behind these allegations for the judge.
The Commonwealth concedes throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications between Ms. Read and her attorney, Mr. Yanetti. 2 of the 3 instances of the communication they cite to are over 9 months old, and that's in 5 months old respectively. So you have 9 months ago the Gretchen Voss statements, and 5 months ago the Vanity Fair statements. But they waited until less than 2 weeks before the start of the trial to bring this momentous and potentially far-reaching and consequential motion. Why? The courts are clear that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial.
And as Attorney Alessi tried to explain that the one case in Mr. Brennan's brief on the subject actually supported the defense team's position in the matter, Judge Cannone interrupted him and denied Brennan's motion out of hand.
The case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrow and tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me to ask, so your motion is denied.
I think a lot of people were surprised by that because, Mr. Brennan has been, I hate to say getting his way, but getting his way. He has scored some points in the pretrial machinations. And as Attorney Alessi started with his arguments, everybody just sat back and listened. So it was kind of surprising when she stopped him, and it is unusual to just be stopped in the middle of an argument, I find anyhow. And she says, we're going to deny the motion. So Mr. Brennan lost one. He lost one. And when he first brought the motion allowing the comments between, or the texts actually between Karen Read and her attorney, I questioned it, and I'm thinking to myself, well, all right, I'll bend over backwards here and try and analyze it. Okay, she went on TV. There's a docu-series that's been airing, and before that, she spoke to Gretchen Voss of the Boston Magazine, and she's talked to other media people. The interview after the Super Bowl, I'm saying to myself, well, all right, so I guess he is saying, well, she waived attorney-client privilege, so give us permission to crack into her phone. But, it's really sacrosanct. And during this hearing, we didn't have time to dig into the whole thing, but they actually pointed out how the attorney-client privilege goes back to the era of Shakespeare.
Well,
And
you need it. It's like, how is anybody going to be honest with their attorney?
And it also goes back to the first case in the United States of attorney-client privilege is in the early 1800s. And so it's something that's really embedded in our jurisprudence. The courts need it. Justice needs it so that people, and we talked about this in our previous episode, so that people can go and have an honest conversation with their attorney, and then their attorney, hopefully anyhow, knows the rules, knows the law, knows how to, frame the thing properly to give them a good defense in comport with the Fifth and Sixth and other amendments in the Constitution. So, and I'm thinking if Mr. Brennan really wants to refer to out of the statements made in the attorney-client privilege, well, he found out by watching the documentary. So there you go. That's it. Now, the next question is how he's going to get that in trial, but that's for another day. So just so much is going on right before the trial. The trial is really shaping up now. There's a pretrial memo that's come out. The defense has filed a couple of shots. There's a new attorney. But why don't we take a look at the fact that Judge Cannone gave Mr. Brennan one by denying the defense's motion to dismiss. Now, I think that we all knew that the motion to dismiss was going to be denied, but some of the grounds in this motion are just surprising. So this is the court's memorandum of decision and order on the defendant's motion to dismiss for extraordinary governmental misconduct. 28 pages. We're just going to skim over and focus on really important stuff. I think she kind of shows her hand right here on the first page. Ahead of the retrial, the defendant has filed a motion to dismiss for extraordinary government misconduct. Such a drastic sanction is justified only in response to the most egregious and truly harmful conduct. In all but the worst cases, the appropriate remedy is at best a new trial, such as the one that is scheduled to begin soon. So you can see where this is going, right?
Mm-hmm.
And now we're going to skip over the background, which we all pretty much know. But, if you're a court, you have to give the background in case this goes up on appeal. Rule 14 of the Massachusetts Rules of Criminal Procedure pertains to the prosecutor's discovery obligations and the materials subject to automatic discovery. The rule in effect at the time of the discovery issues here provides that the prosecution shall automatically disclose to the defense certain evidence, quote, relevant to the case and in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction and control, or persons who have participated in investigating or evaluating the case. And there's the Rule 14. This includes any facts of an exculpatory nature. So remember this when we get up to some of the coming up pages. This includes any facts of an exculpatory nature and material and relevant police reports, photographs, tangible objects. And by the way, the Superior Court rules in Massachusetts define photographs as including videos. So remember that as we go forward too. Tangible objects, all intended exhibits, reports of physical examinations of any person or of scientific tests or experiments, and statements of persons the party intends to call as witnesses. Canton Police Department surveillance footage on January 29, 2022. After O'Keefe was found dead in the snow outside the Albert residence in Canton, Mass., police towed the defendant's vehicle to the Canton Police Department, CPD. There were multiple surveillance cameras in use at CPD that captured the defendant's vehicle on a flatbed tow truck as it entered the Sallyport at approximately 5:30 p.m. There were also cameras inside the garage where the vehicle thereafter remained. According to the Commonwealth, surveillance footage from these cameras is automatically overwritten on a regular basis. Footage from the night in question was not lost, however, because CPD Sergeant DiGiampetro followed his customary practice of downloading the recording to a hard drive in 6-hour segments. Okay, so why wasn't all that turned over at that point? Okay, here's the answer to her question. The lead investigator in the matter, Mass State Police Trooper Michael Proctor. Does that answer the question?
Oh my God, I hate these people. There is like this case in New Jersey where there's like this crazy cop who's been like using the bathroom on the floors and trying to prank all his coworkers by doing obscene stuff and drugging them. And now I'm like sitting here looking at this Proctor stuff, and Proctor's taking footage and just doing whatever he wants with it. And it's going from place A to place B. It's like, oh my God, what is going on in our law enforcement sometimes? Oh my goodness.
So the lead investigator in the matter, Mass State Police Trooper, terminated State Police Trooper, I should say, Michael Proctor, took possession of requested CPD video of the Sallyport in February 2022, but did not turn it over to the prosecutors. Instead, for reasons unclear on the record, he kept the material in his case file. All crime scene photographs okay, so this is the order that was sought and received on June 9th, 2022, after a Norfolk County grand jury indicted the defendant on charges of murder in the second degree, manslaughter while operating under the influence of alcohol, and leaving the scene of personal injury and death. On October 5th, 2022, this court issued an order directing the Commonwealth to provide the defense with, inter alia, all crime scene photographs and or videos taken in connection with this case, including but not limited to photographs documenting the purported recovery of pieces of white and red plastic outside the residence located at 34 Fairview Road on January 29, 2022 and February 4th, 2022, including the metadata associated with these photographs and videos. Several months later, in June of 2023, our friend Mr. Proctor asked CPD whether it had in its possession any exterior Sallyport video showing the defendant's vehicle on the flatbed of the tow truck on January 29th, 2022. In response, Canton Police Department gave state police the video from the main driveway side exterior Sallyport camera. Proctor took possession of this video, but again, for reasons unexplained, did not turn it over to the prosecutors. Instead, he placed it in his case file. This footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the CPD garage. And this is where it gets a little bit shady. The recording is dark, blurry, and grainy, and the condition of the passenger side taillight, a significant issue in dispute in the case, cannot be discerned. So look at this. We're still facing redactions in this case, even though the rest of the motion has been made public. 3 months later, on April 4th, 2024, and this is just before the trial started, ADA Adam Lally received Proctor's federal grand jury testimony. After reading Proctor's testimony, Lally asked the trooper if he was in possession of the video footage referenced therein. In response, Proctor gave Lally the Sallyport front wall camera footage provided to Proctor in February of 22, so 2 years later, but not the main driveway side exterior Sallyport footage provided to Proctor in June of 2023. Lally immediately turned over, of course, Lally's a good boy, so he immediately turned over the Sallyport front wall camera footage to the defense, along with footage from the CPD main driveway showing the SUV on the flatbed. None of this footage contained a view of the back of the defendant's SUV. On April 10th of 2024, we are right in the middle of the, right a couple of days before the trial, April 10th. Jury selection started on the 15th. Lally filed a certificate of compliance indicating that to the best of the Commonwealth's knowledge and after reasonable inquiry, it had disclosed and made available all items subject to discovery pursuant to Mass R Criminal Procedure Rule 14. When defense counsel reviewed the Sallyport front wall camera footage, they saw that 42 minutes of footage was missing. Oops. The defense raised the issue to the court at a hearing on April 12, 2024, days before the trial was set to begin, arguing that the missing footage was critical to the defense's theory. The Commonwealth explained that the footage was intermittent because the camera was motion activated.
Some pretty fancy technology to just cut out some video for something that you would want security footage of, huh? Never really heard of that.
Yeah, I don't know. Plus, they bring the vehicle in and people are walking all around it, so you'd think that there's a lot of motion in there. So the trial starts on April 16th. I said the 15th, April 16th, with the first day of evidence actually April 29th. Took that much time to select the jury. On April 17th, Lally received footage of the Sallyport interior back wall camera from the CPD, which had been looking for continuous camera footage of the Sallyport on the relevant date. April 23rd, 2024, Lally provided the Sallyport interior back wall footage to the defense, and the images contained in that footage were inverted. Okay. State Police Sergeant Buchanan testified on June 5th and 6th, 2024. During his direct examination, Lally showed the inverted Sallyport interior back wall footage in open court. Because the video was inverted, what appeared on screen as the right side of the vehicle was, in fact, the left side and vice versa. We remember this. The direct testimony did not alert the jury for 2 days that the video was inverted. On cross-examination, however, defense counsel questioned Buchanan extensively about the inverted footage. The CPD began a review of other video surveillance footage in an attempt to explain the inverted footage and to respond to allegations that it had deliberately manipulated the recording. As part of this process, Canton Police Department Chief Rafferty reviewed the surveillance footage from cameras in the hallways and the parking lot at the CPD in the early morning hours of January 29, 2022, prior to O'Keefe being discovered in the snow. The rear lot cruiser side camera had recorded ATF agent Brian Higgins, a witness called by the Commonwealth at trial, walking across the parking lot at 1:34 a.m., holding a phone near his face.
Just calling, his friends, family at 2 a.m.
Yeah. In September 2024, Special Prosecutor Brennan joined the prosecution team. On October 10th of 2024, he provided the rear lot cruiser footage along with other surveillance videos. The CPD interior hallway, the church side exterior Sallyport, the rear lot main side to the defense. So this goes on, and we've seen some of this. The defendant argues that the Commonwealth provided an untimely disclosure, withheld or destroyed certain CPD surveillance video in violation of Rule 14 Brady and the court's preservation order, an October 5th, 2022 order on motion to compel discovery. Jump down here. This argument is flawed in several respects. So the judge gives her view of the facts. Then she gives a paragraph to the defendant's arguments and just says it's flawed. And we're going to look at a couple of these reasons. And first, contrary to the defendant's argument, there was no court order requiring the Commonwealth to preserve or produce the CPD surveillance video before the first trial. And that's wrong. This is wrong. Why do I say that? The February 2nd, 2022 preservation order required the Commonwealth to preserve all physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene. See Defendant's Exhibit A. This order did not extend to the surveillance footage from the CPD. Massachusetts case law reflects, Go back to the beginning of this paragraph. This is wrong. First, contrary to the defendant's argument, there was no court order requiring the Commonwealth to preserve or produce the CPD surveillance video before the first trial. But wait a minute. Here's what the order said. The February 2nd, 2022 preservation order required the Commonwealth to preserve, in yellow, all physical evidence. All physical evidence. Remember, we talked about the rule that said any videos, any photographs. So then,
how are they gonna? Okay, hold on, because this is such a good point. Because they're saying all physical evidence. Yeah, video surveillance is digital, but you know what's not digital? The hard drive that they saved it onto. So yes, there was physical evidence. Anyway,
well, my point is a grammatical one. All physical evidence. Then there is an exemplary phrase, not a limiting phrase. It doesn't say all physical evidence, but this is what we want. It says all physical evidence, then by example, including anything present or near the decedent at the time his body. Do you see what I'm saying? It's the phrase is not a limiting clause. It doesn't say, all right, all physical evidence such as. It says, yeah, it says all physical evidence, including. Now, it could have been better written by saying include. Usually attorneys say including, but not limited to. But that's kind of implied. So I think that the grammatical inferences, I think the grammatical construction of the order does require that anything having to do with the case should be provided. Plus, also remember that the Commonwealth's theory is that the Lexus is what killed John O'Keefe. So it's the M weapon. The car is the M weapon. So obviously anyone with half a brain would see that it is part of the evidence. It's part of all the evidence. So we're coming to a part that I think is going to make you mad.
No, I'm already mad.
Moreover, where the physical evidence described in the preservation order was further defined as including anything, including, not only, not limiting it, but as including anything present or near the decedent at the time his body was discovered. The order cannot this is totally wrong. The order cannot reasonably be interpreted as that's an opinion and it's wrong.
What about the hard drive? How is the hard drive related to the night of the incident, not physical evidence? Like, you can argue that the video itself is digital evidence. It didn't call for digital evidence, but there is physical evidence. And like you said, it's the M weapon, alleged M weapon.
Oh, you're all mad now. You're all worked up now. Wait until you read this paragraph here on page 13. The defendant also argues that the Commonwealth has violated Rule 14 by failing to preserve all the footage with the metadata. There is no merit to this argument, young lady. The defendant did not make any specific request for the original footage with the metadata before the first trial or before it was overwritten.
They downloaded it.
There is nothing in the version of Rule 14 then in effect, or the current version, by the way, that entitles the defendant to the metadata or log files underpinning surveilling footage in the possession of the Commonwealth, and the defendant has not directed this court to any authority suggesting preservation of such evidence is required.
How are we going to trust any evidence in this new generation? It is 2025. You go on Facebook, when you scroll down Facebook, 90% of everything you see is stupid AI garbage. So how are you going to tell me? And like, also not even just like the post, because how many times now at this point have you seen videos of just like random like things? Like, I've seen cats on Instagram like cooking in the kitchen, doing all whatever with AI. If the defense isn't entitled to the metadata, how are we supposed to trust anything we see? Anything can be compromised. Why is there no reason that both teams deserve to have the metadata?
Well, I knew this was going to work you up. I knew that you were not going to like this, but what I was going to say is it's common sense. The defendant argues that the Commonwealth has violated Rule 14 by failing to preserve all the footage with the metadata. There is no argument because they didn't, it's common sense. You don't need a rule. You don't need specifics. It's common sense. I mean, it's common sense that you don't stand up and whistle Dixie in the middle of a trial. It's common sense that you don't go out in the middle of the street and go, blah, 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 blah. It's common sense in 2025, or actually, we'll give them the benefit of the doubt, 2022, when all this took place. It's common sense that if you're going to give an honest portrayal of unedited, unfooled around with video, You give them the metadata. I knew, I'm no professional when it comes to photography. I've taken some photography classes, but I'm only this much better than a point and shoot person. But even I know that you go into the metadata, and that's what shows that it's authentic. So to say that there's no merit to this argument, it's common sense. So I think you get the gist of this motion, and the judge does come out and say that there were things that were done wrong. She does come out and say that there were things that didn't necessarily pass the smell test. But bottom line, what Judge Cannone is saying in the motion is it's too draconian, is the word that she used in the order. It's too draconian to dismiss the case. The remedy here for the misdeeds that she does acknowledge the Commonwealth took part in, the remedy is give him another trial. So it makes me shake my head. Did you have some things that the commenters were going to tell us?
Oh my gosh, well, these commenters, we are equally as disturbed as we are at this point.
Am I disturbed?
Oh, I don't know. I mean, you should be. So these are some comments from one of our previous videos related to the topic. I will start us off with Caroline Brisbane's comment. Brennan has put Yanetti, Little, and Jackson on the witness list. Also, I'm going to say these are our viewer comments, not indicative of our own opinions.
Right.
Ridiculous. Ridiculous. He could go straight to Voss instead, but no. Asking judge again to get rid of her lawyers because they can't represent her and be witnesses, or he's using to wind up judge. Also, police says they have her on ring video of her hitting him, so she was questioning context matter. Also, someone rang Yanetti stating OJO fight inside the house, and then they backed out. So it's a lot going on in this comment and a lot going on in this case, and a lot of, like, if people watching this case are all types of confused, how is the jury handling this is my question.
Yeah, one of the TV stations in Boston said that there was actually ring camera footage of Karen Read's Lexus backing into John O'Keefe.
Where is
it? There is none.
Yeah.
There is none. And they ran a little teeny tiny little retraction, past the underwear ads, and nobody, so.
All gone. It's just like, oopsie, just a joke, just a funny little joke.
Yeah.
All right. So now, if you wanted to read Jackie's comment.
Jackie F3U. Brennan has lied, but Aunt Bev allows it. Brennan is a snake.
Our viewer comments, not ours.
we try to keep this on the up and up. This is a legal analysis channel, and I know there's channels out there, some of them by some people that I like, that they get into the name calling thing, but we try and stay above this. But anyhow, Hank is friends like Morrissey with the other side. They're trying to get rid of Karen's defense team. Yeah, they were trying, and they didn't let Mark Betterow on. So, but now they have a new attorney, and in our next episode, we're going to talk about the new attorney.
And also, too, it's just like Brennan has lied, but Aunt Bev allows, Miss Cannone allows it. Another point with that, too, is like we've talked about the whole grave concern issue where it's just like, oopsie, I was wrong. That didn't come from the feds, that came from the defense. So, yeah, serious issues at hand. PJ. 222. It was supposedly announced the federal investigation was closed. However, with Proctor found guilty, dishonorably discharged, I imagine even behind the scene that investigation will resume. Is that a thing?
I doubt it. No.
Yeah.
I doubt it.
Corruption indicated and exposed. Yeah. Also, like, they don't care. Like, the Commonwealth is on a fishing expedition. I can't help but notice we're hearing a lot about fishing, and considering that he was trying to get the deets on her phone, makes sense. And searching Aiden Kearney's cell phone is a Hail Mary antics for a case they claim is open and closed. I call their bluff. Proctor is the domino to bring down the corrupt house of cards and all those involved in the cover-up. Again, this cover-up framing of Karen Read's death of the officer John O'Keefe. None of these dark characters ever attended his funeral. Very telling. Justice for Karen and John, victims of the Canton crime circle. And again, this is our viewer comments. But again, echoing similar sentiments that we've seen before.
Yep.
And this one is very long, so I apologize to you, Andrew.
Zebra fan. That's how I read it. When Mr. Dishonorably Discharged Proctor said he didn't deny the texts, it didn't affect his work in the case. It doesn't matter. The appearance of bias is enough to say there is bias. His superiors, some of whom received the text, should have reassigned the case right then. I can just imagine myself after having a beer or two, disclaimer, certainly not drunk or even close to the limit, and driving in the Boston, Newton, Canton area on my way home. You know what? Driving in Boston, Newton, Canton is bad enough on Route 128. You don't want to be drinking anytime, but, that area, forget it. If Proctor smelled a little beer that was spilled on me, would he believe it if I said, I only had a couple of beers, but they in no way affected my ability to operate a motor vehicle? No way. He'd have me on the side of the road doing, yes, you better bet that he would, doing your field sobriety tests, which I inevitably failed because of several issues with my back. They all say that. It was the mouthwash that I used before I got in the car that smelled like I've heard it all. I used to do a lot of OUI defense. I don't anymore, but we've heard it. Okay, I'm sorry. I deviated from the comment. Not because not all MSPs have PBTs in their vehicles. He'd arrest me and take me to the station to do a breath test and then find I am not over the limit and let me go. Then I'd have to find a ride to the tow yard and pay $275. Oh, that's all it is? I thought it was more than that. Anyhow, pay $275 to get my truck back and go on my way. I thought for certain the MSP would wait until after the second persecution of Karen Read to make a decision. I'm so glad they didn't. FKR, free Karen Read. By the way, I love Bruce Rivers' videos. We all do. He's fantastic.
So this one is from Victor Salvage. FDR had great capacity for educating the public about questions of principle. Andrew D. Myers has FDR skill in reducing difficult questions of principle to common sense terms. Would you consider running for office?
No one has ever compared me to FDR. I mean, I'll accept the compliment, but I mean, I've never heard that one. And B, no, politics is not for me. I have no patience. I listen to people. I go to some town meetings. I've actually been on some. I listen to people and I want to get up and give them one. So politics is not for me. I was involved in the student government when I went to Suffolk Law School. And that was enough for me. That taught me no. Politics is not for me. I'm an independent. I've been an independent since I was a little kid. And that's all I'm going to say.
But not only that, Andrew, you're too young and in too good of shape to be a politician, in my opinion.
Thank you.
All right. And now this is not on our Karen Read video. It was one of our more recent comment videos. But I thought it was relevant to this video. Howdy says, I feel bad for the officer who got backed into by the jerk YouTuber, which if you haven't seen our video on the YouTuber Hit and Run, please watch it. We do some viewer commentary, and then we get into the story of what happened in New Hampshire with this guy. Got backed into the jerk YouTuber, but can we pair his injuries to Officer John O'Keefe? I know. And I'm assuming the I know is just like sympathizing, it's just like, it's not practical. But I saw this comment and it kind of blew my mind because that's such a good point where this guy hit the officer, sent him going allegedly 20 feet in the air, and the officer is alive and, injured, but so we're talking about Karen Read backing up into John O'Keefe, and the only thing we have are scratches on his arms.
And this guy was driving a large black SUV also. I don't know what model it was, but it was a very large black SUV. Big SUV. Yeah. Hit him in the leg.
Yeah. I just saw this and I was like, that is such a great point because this guy got hit by a car speeding at 1,000,000 miles an hour and was still fine. And Officer John O'Keefe, and obviously we don't know, we're not witnesses, we don't know what happened that night, and innocent until proven guilty, but whatever the court decides we will settle with. But at the same time, you're telling me that she backed up to him, reversed, accidentally backed up to him, threw him into the snow, and that was what did him in. Is just like, and that we're
Why
not.
Do you think, Why do you think Hank Brennan is mad as a hornet and trying every single angle he can to discredit, to get rid of, to eliminate, and otherwise, just give the boot to the ARCA experts? Because the ARCA experts, who are, PhD engineers, said John O'Cape was not hit by that Lexus, and B, the Lexus did not back up and hit him. And that wasn't the cause of his injuries. So why do you think Hank Brennan is, mad as a hornet and trying to get those experts out? He has his own experts, which we could talk about in another episode. But, this is a good point. Good point. Okay.
Yeah. I know that comment wasn't necessarily directly on our Karen Read videos, but I was like, that is such a great point. I didn't even think about that, where this guy went flying in the air. And I'm not going to say it's totally fine because he's injured. He's very injured. But you're telling me that we backed up into someone, launched them into the snow, and a couple of scratches on their arm is the injury? I don't know.
Makes no sense. Makes no sense.
We do appreciate your comments, though. So anyway, thank you guys so much. We appreciate your comments. My final thoughts for today is, you guys always give me things to think about. I mean, I'm glad to see that, we're not getting into anybody's cell phones. I feel like that, like trying to break down the attorney-client privilege is the least, that we can hope for. I was a little bit worried, I'm not going to lie, when they were asking for those records, but I'm glad that at least worked out.
My final thought is this, and that is that, there are a lot of people out there that are going to be doing live gavel-to-gavel coverage from 9 in the morning till 9 at night, after they get done talking about the whole thing. We are going to, because both of us have, this is our side gig. We've been called, part-time grifters. So what we will do, we don't have the ability to be live. I still practice law. I'm busy. I got stuff on the schedule I've got to address. So what we're going to do is, same as we did in trial 1, we will watch everything. When I go home at the end of the day, I watch it all on YouTube. I'll take notes. We'll keep tabs on what's going on with the witnesses and the judge and everything else. End of the week, on Saturdays and Sundays, we'll drop summaries. We'll highlight, the things that are really, really, really important. So if you can't sit by the computer or the TV and watch the whole thing live and listen to people talk about it, we'll be there for you with a summary at the end of the week. So thank you very much. We appreciate you being here, and we'll see you weekends.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
So the motion is denied.